classmate. Tonight I will be reporting under Book 4, Title 1, Obligations, Article 1178 of the New Civil Code of the Philippines. So before we go to the main provisions of Article 1178, we must, to understand the provisions of Article 1178, we must first have the definition of terms. We will encounter discussing Article 1178. So we will encounter there inter vivos, or in the context of deed of donation, inter vivos is a phrase to describe a gift that is made during the donor's lifetime. So a legacy bestowed during the donor's lifetime which has immediate alienation or effect. Another term is mortis causa, or literally mean upon the death. In the context of donation, the literal meaning upon the death of the donor. So a legacy bestowed during the lifetime of the donor but will take effect only after the death of the donor. So another term that we will encounter is transmission. This is not in the context of civil law. This is not. This is defined as the right of the heirs of legatees or that may have of passing to their successors the inheritance of legacy or to which they were entitled if they have happened to die without having exercised the rights. So in the context of civil code, so I was taught by one of my friends about the article in civil code, which is also my favorite, article 777, which is the right of the legatees to the property upon once the registered owners of the properties are already not in this world. The heirs or the legal heirs have the immediate right as the owners themselves of the properties. Subjective novation. Subjective novation is defined when a new obligor is substituted for a prior obligor who is discharged by the obligee. So there is already a termination of an obligation and institution of another obligee. The previous obligor obligation is already terminated by substitution of another obligor. So subjective novation can be an exercise is about the corporate law when a corporation has been taken over by another company, and then all of their credits and obligations will be absorbed by the buyer. So they will not, the new owners of the company will be the new obligors of the obligations of the previous owners of the company. That is what is can be an example of the subjective novation. Termination of the previous obligor, but the obligation will be transferred to another obligor, subject to the, of course, the stipulation between the obligor and the obligee. There is a third party here, third party obligation. Intuitis personae. literally meaning for literal meaning for because of the person. Yeah, literal meaning is for because of the person. Yun.
Yeah.
So this is defined as in the context of obligations and contracts, the parties expressly agree that the agreement is entered intuitive personae or therefore undertake not to transfer the rights and obligations incumbent upon them in whole or in part by virtue of this agreement without prior written agreement for the party. Example of intuitive personae obligation is the involves the performing arts, an actor, singer, yun ang intuitive part. There will never be a transmission of obligation because of uh, uh, party expressly agree that the agreements entered intuitive person. So Article 1178 provides that subject to the laws, all rights acquired in virtue of an obligation are transmissible if there has been no stipulation to the contrary. So this is a very simple provision of the law which states that uh, all rights or all obligation are transmissible except of course if there is an stipulation. So what are the general rule? The general rule in the transmissibility of rights. The general rule in the transmissibility of rights as well as liability arising from the obligation either inter vivos or mortis causa. The same cause is laid down in contract law. The transmission of an obligation inter vivos might be by virtue of a subjective novation. So as we discussed earlier, the definition of subjective novation is the uh, obligation is discharged to another person. Subjective novation occurs when a new obliger is substituted for a prior obliger who is discharged by the obliger. This is the best that I can have as an example. Example is an agricultural leasehold contract by operation of the law can be transmitted to the wife or the eldest child of the deceased tenant. Transmission mortis causa takes takes place by virtue of succession. So if there will be if a person has an obligation and he died suddenly, so transmission of the obligation takes place by virtue of succession. So if the obliger pass away, and by virtue of succession, the his estate must must uh, must must pay first the obligation incurred during the lifetime of the uh, owners before the transmission could be could take effect. The transmission of the ownership. Second, there are exceptions to the rule of transmissibility of obligation. A. Obligation which by law or by nature are intuitive personae. Intuitive personae, a personal service contract for the particular. So if there are, and then second, as the second paragraph of this element of the As the law states, unless there is an stipulation, obligation declared intransmissible by agreement. To illustrate the provision of this law, I digested Siguan versus Rosalim et al. The ponente is Chief Justice Hilary David Jr. I digested this from El Mirabuya book, page 86. This is under a footnote. So in short, Siguan is a creditor of Rosalim. Rosalim has about 5 properties, and in 19 prior to this prior to the obligation she got from Siguan, she donated her properties, 4 properties in Cebu, to her 4 children. So it is actually action Pauliana because Siguan was able to get a conviction for estafa, or right. So there was a conviction regarding there was a rescission of question on deed of donation from teka, ano nito? Versus ano ito? There was a conviction for a crime of estafa filed by a certain convicted 5 by 1 is under the donation was subsisting before the the Court of Appeal reversed the decision of the RTC because there was a rescission ordered by the Court of Appeals because of the action Pauliana. This is actually an action Pauliana case. Pauliana case. The issue is whether or not the deed of donation was entered into by Rosalim. Affirm. Reverse kasi. Ano to? August 10, 1989. So there was a deed of donation. I think the deed of donation was in 1987.